Hi, everyone. I'm Brian Manning. I'm a financial advisor for Pinnacle Financial Partners here in Nashville, Tennessee, and I'm the host for the Pinnacle Point webinar series. I am thankful to be joined today by two friends from Bass, Berry & Sims, David Thornton and Doug Dahl. We're also glad that you joined us today. You know, Pinnacle's brand is built on distinctive service and effective advice, and we look for ways to enhance our relationship with our clients and with our friends in the communities where we do business. And I'm so thankful for my friends in the trust and investment services area who have sponsored this event today, because I have bank clients who manage and run businesses, and they know those businesses well, but they depend on us for effective advice and how to manage the finances of that business well. And they come to us for general banking needs, but so many times it goes beyond general banking needs. And I'm so thankful that we've got our friends in the investment and trust areas here at Pinnacle Financial Partners to help with that. I'm thankful for their relationship with our friends at Bass, Berry & Sims, who are going to spend a little bit of time with us today. David and Doug, we're so thankful that you spent some time with us to share your expertise to help all of our participants understand how to more effectively manage and run their businesses today. Just a couple of housekeeping items before I turn it over to David to start the presentation. We have turned on the question and answer function. So if you've got a question for either David or Doug as we go through the presentation today, please submit it through the Q&A function. And I'll be managing that and watching for your questions, and we'll share those with the presenters at the end of their presentation. Also, if you'd like to go back and watch any part of this, once we're done, we are recording this and it'll be available on our YouTube channel. You can find that by going to www.youtube.com/watchpnfp, or if you just pull up your YouTube app and search Watch PNFP, you'll be able to find this here. If you can't find it either one of those ways, just reach out to your financial advisor and we will be able to share that with you immediately. We're thankful that you're with us. David, I will turn it over to you. Thanks for spending some time with us this morning. I'll let you take the reins and have at it.
Thank you, Brian. David Thornton with Bass, Berry & Sims, and you should also be able to see Doug Dahl, one of my law partners. We obviously we're in our employee benefits practice group. We deal, pretty much daily with retirement plans and welfare benefit plans, and we work, of course, predominantly with large employers, or any size really employer, but on compliance issues and a lot of fiduciary issues. And so, Doug, if you want to say hello real quick, and then we'll just jump into the presentation.
Yeah. Well, thank you all for having us. We hope today's presentation is relevant for your businesses, and we really would encourage questions, because we definitely are going to leave time at the end to answer questions. I know there are already some initial questions, but if questions come up during it, David and I would really like an opportunity to go through those questions. So thanks for joining us today, and we'll get started.
Yes. Right now, a quick overview of today's presentation. There's been a lot of activity in record keepers consolidation, and we thought we would touch on some fiduciary considerations that you should go through a consolidation on your record keeper, just a thought process, a due diligence that you'll have in mind. Also, a lot of just merger and acquisition work we're involved in, and again, there's that's required specific to retirement plan. Doug's going to cover those due diligence. We thought we would also just kind of go into some regulatory matters that are happening in 2021 and give you a quick update, and also maybe a quick update on retirement litigation, time permitting. But as Doug said, we really do want to make time for question and answers, and so we will get started now. And I am going to have to ask each time to turn the slide. So I'm just going to say, Lynn, next slide as we go. And so next slide, please. Okay, record keeper consolidation. Over the past few years, the rate of consolidation on record keepers in the 401k business in particular has been just very aggressive. I listed just a few, and just very recently, Empower announced its acquisition of Prudential. But as you can see, Empower has been doing a number of acquisitions, as has Principal. Transamerica has very involved. Again, they acquired Mercer just a few years ago. One America, Mass Mutual, it's a very growing trend. And what we're seeing is fewer providers now control a much larger portion of the market. And we think this trend will continue. Over the last 10 years, it's estimated the number of record keepers has moved from 400 to less than 150. That's a 2/3 drop. 85 to 90% of the 401k, let's say, plans are now consolidated into the top 20 providers. So what we've discovered is a lot of plan sponsors may have picked a record keeper 3, 4, 5 years ago, but they're no longer with that record keeper due to a consolidation. And so we thought it would be helpful to go through fiduciary consideration if you're ever faced with a record keeper consolidation. Next slide. Overall, and I think everybody understands this, that a plan fiduciary under ERISA has a responsibility to undertake a prudent process in selecting and monitoring service providers, and that's in particularly true for record keepers. So if your record keeper is involved in a consolidation, whether it's being acquired or acquiring another record keeper, that's going to trigger ERISA consideration. You're going to have to go in, you need to understand how that consolidation will impact your plan and the participant, your level of services. So basically, this should be a trigger and put on your fiduciary hat should this occur. Next slide, please. So I wanted to start quickly with your basic fiduciary duties. The first one is the duty of loyalty. We call it the exclusive benefit rule. The next one, we would say the duty of care. This is really the one we want to talk about today. It's also referred to as a prudent expert rule because care is not judged as a lay person. It's judged as if you're an expert in the industry. So we will talk more about how we meet with that duty of care. The duty to diversify and the duty to file a plan document are your 4 basic fiduciary duties, but we're going to concentrate on the prudent expert duty. So next slide, please. So the way you satisfy the duty of care is all about a process. And we call this a procedural prudence is needed. And so it's the process of fiduciary decision-making is the key. So fiduciaries need to go, and this is from some case law, they need not predict the future, but they must engage in a reasoned decision-making process. If you are able to establish a process and it is documented where you have gone through a reasonable thought process, the chances are is you have met your duties well. And we see from case by case, a court would look at the process, not the result. So a bad process, even if you had a good result, still might be a fiduciary problem. But documentation of the process is the key too, because it's the only way you're going to be able to go back in time and show, here's what we did, here's our thought process, here's the alternative we considered, and here's the conclusions we reached. So procedural prudence, what does that mean when they're faced with a record keeper consolidation? Well, next slide, please. I've kind of went back. I went through one very recently with a client and kind of went back into what we did. There's no one size fit all, but this is kind of, I thought, was a very successful approach. Once we received notice that there was a very large acquisition that was including our record keeper, the light switch flipped on pretty immediately. We started attempting to find out as much information as we could from our existing record keeper as to the transition and when it was going to occur and the reasons behind the consolidation. So as we started that gathering of facts, we formed a transition team, and we pulled from different parts of the plan sponsor's workforce. Obvious members were human resources, the benefits administration, you're going to payroll, and in particular now information technology, because of the security standards that are so aggressive right now on participant data. We also brought in members from the investment committee, the committee that oversees, the quarterly review of investments and adopt the investment policy statement. We also got financial advisors, who's really actually indispensable in this process, and the other consultants that perhaps work with the plan. Legal also, we brought in representatives as needed from the incoming and outgoing record keeper, at least established contract, and we also talked to the trustee. So this was kind of our team that we assembled, and we initially started by having a, let's say, kickoff meeting, but it was one where we trained on fiduciary duties. It's the very first thing we did to make sure everybody understood that we're about to engage in a process that we're going to be prepared to understand your responsibilities, your duties, and also the ability to prove our thought process at the conclusion. Next slide, please. So I think the very first thing we looked at is, okay, we are faced with a record keeper consolidation, and do we have a say in this? And yes, you do have a say in this. And we looked immediately to how are we going to benchmark the new record keeper. We hadn't even really made contact yet with them. We hadn't received proposals. We haven't had anything definitive on how the transition was going to take place. But the first thing we did was start working with our investment advisor and tried to make a determination if we should go through a new RFP. And everybody, the RFP is where we would actually go to the market and accept other vendor considerations. They're a great process to go through. We recommend them every 3 to 5 years. They're not legally required, but it certainly lets you know what the market looks like and what your alternatives are. If you're not, then yes. That Doug? I'm sorry. No. I thought you asked a question. I'm sorry. If not going to do an RFP, then we got to figure out how we're going to benchmark. But if you are going to do an RFP, you got to get started quickly. It's not a quick process. You got to have your investment advisors, and I actually get very involved in them because we're going to reach out to different record keepers and get proposals from them. So that I think would be one of your very early considerations in evaluating the record keeper consolidation. The next thing we did during this process is become very actively involved with the incoming record keeper. We found a contact, a representative, a go-to person to ask questions, gain information along the same process as we simultaneously went through an RFP. We also worked very diligently at creating a participant communication chart. We wanted to know timelines on when we would announce transitions. We need to know that from the incoming service provider when the transition of our plan may occur, but we wanted to get in front of communications very quickly. As you know, that's just vital to the plan participants. And then we started really working through a process and evaluating a record keeper. We took existing, yes.
David, what issues have you seen specifically around participant communications that people should be sort of, tuned in on? What issues have you seen there?
Well, what we were faced with were, a lot of the communications were going to be prepared by the incoming service provider, the incoming record keeper, and they were fine, but they really weren't drafted in a way that we preferred. We wanted to be involved in the draftsmanship of those communications. They were kind of one size fit all, and we were very customized. We were in our approach to our participants. So that was a big issue because the participants had a lot of questions, and we were very much in FAQ format in our communications, and not just, a one page, here's what's going to happen. The process we started next was the selection of the record keeper. We would looked at our existing contract. We looked at the fees. We actually started negotiating a new service agreement very quickly. We wanted to get ahead of the game on limitations of liability, standard of care, performance standards. So, a lot of that we started way early. I do encourage everybody to really concentrate on employment agreements quickly because you have your leverage when you haven't committed that I'm going to make this transition. And that is the time to be able to negotiate terms more favorably. We created actually, next slide, please, a pro versus cons analysis. And these were common charts on each one, the common pros, and I'm not going to go through them all, but the services that we were going to receive looked more robust. Technology seemed to be an improvement, a lot of emphasis on financial wellness, which we looked on very favorably. The cons, the biggest one was time consuming, the demand on the sponsor, worried about decreased services, really worried about investments mapping. But really the key, the one the most was the uncertainty that, would it be a successful merger of two very large, record keepers, their technology and culture, and what would be the end result. So this was just one that we did during the process. I think it's a good thought process to go through for your procedural prudence standard. And then we created, next slide, please, basically a checklist of what we wanted to do. We worked in the interest of time, I'm not going to go through each of these items, but the top three, when we're dealing with the record keeper, the reputation, the goal, investigating the services, we really work closely with an investment advisor to the plan. It pushed us down the road immensely, benchmarking and also working with the mapping of investments. So this one is we created formal documents on each of these points, and we retained them in our file for future reference. So those were the most important of which is kind of hard to just say one, but identifying conflicts of interest, any prior litigation, negotiating the record keeping agreement, making sure appropriate standards on liability. And also, this was occurring right when the DOL issued its new cybersecurity audits. So we were very mindful to document those issues. So each of these points really became a separate documented thought process during our procedural prudence review.
David, quick question. If the record keepers want the client to execute a contract assignment, are there certain things that the clients should be aware of and advisors be aware of when they ask for a contract assignment?
Well, absolutely. The assignment was really the route what was asked of us. We were presented a fairly short agreement. It was just an assignment of our existing contract, and our existing contract was about 3 to 5 years old, and we were more interested in maybe bringing a contract fully negotiated up to date. The assignment that was presented, basically, and again, it just wanted our consent to the transfer of the contract to the new income and record keeper, but it also had a lot of provisions in such as releasing the prior record keeper from liability, waiving claims, which we just couldn't do. So that was, I would say, an assignment is the easiest way, probably the most inexpensive, but the document, though it looks to be short, may be very advantageous to the prior record keeper and the future one. So I would look at it very, very hard, and I would strongly recommend pursuing an entirely new agreement. And with that, next slide, please. As we said, that process, that checklist, we've created, I mean, a file just this big. We had committee meetings, we have minutes, we documented everything we did from beginning to end. And we transferred, as I've said, to the new income and record keeper. But we feel like we had the ability and certainly could have decided differently. But it was ultimately determined that it would be in the plan participant's best interest. So with that, I was saying document. And I know we're going to want to create time for Q&As. I'm going to turn it over to Doug now to kind of walk through a retirement plan due diligence thought process in the event you are involved in a merger or acquisition.
Sure. Thank you, David. And the one thing I wanted to mention on the last slide in terms of a prudent process, I know that probably every time you talk to your advisors and legal counsel regarding retirement plans, we mention prudent process, but I was reminded about how important that was reading a case last fall, and it was a federal district court case where the court said, if we had to look at this case de novo, meaning if we had to look at it without the favorable standard of review that fiduciaries get if they go through a process, we would have decided against the fiduciary and against the plan and for the participants. And the court said, because of the favorable standard of review, that the tremendous deference that fiduciaries get if they go through a prudent process, the court basically said, our hands are tied. We have to, rule for the plan and for the fiduciaries. So we sent that case all around our group because we always hammer, procedural prudence, and this federal district court case made the case for us of why it's so important. So I just wanted to kind of mention that, and we can go on to the next topic.
Hey Doug, if you don't mind, let me jump in just real quick, because we did have a question from John before we shift gears a little bit to talk about the timeline for when this needs to happen. If you are faced with a record keeper consolidation, is there a specific timeline that your due diligence needs to begin? And if there's not something set in stone, what's your recommendation for when you begin that process?
Well, there is not something set in stone. It's a fact and circumstance. And, all plan sponsors have other businesses. So in some sense, it's something new coming in. But I would start pretty quickly, because the sooner that you start, I think it's showing you're exercising your due diligence. And that's what we want to do. We want to show that we are making active, inquiries, and we want to document our inquiry. So starting as far as doing an RFP, that's going to take a couple of months to put together by itself. So as far as the transition team, I would think you would have one together within the first couple of months, and the process would really be kicked off.
I think that's helpful. All right, Doug.
Right.
Turn it over to you.
And Doug, I'll just throw something out for Doug, and with the positions and his point. As you go through this, touch on when there's a fiduciary consideration versus what we call settler function, which is more of a corporate consideration. I think that would be helpful for people in understanding when it kind of gets blurry and when it's very clear.
Got it. Thanks, everyone. Yeah, just switching gears to retirement plan due diligence in mergers and acquisitions. Next slide, please. Yep, there we go. So we thought we would just broaden the discussion, beyond just M&A in the record keeper, plan record keeper world, but sort of broaden it to retirement plan due diligence in mergers and acquisitions in general. As you can see from this slide, the level of M&A activity in 2021 has been staggering. You all probably know that just by watching the news and hearing terms like SPAC and de-SPAC and massive deals, pretty much every week. According to an August article from PwC, the annual U.S. deal value in the last 5 years averaged about 1.8 trillion, but through May already, the deal value was already at 1.4 trillion. So if that trend continues, and I think experts are expecting deal activity to continue on like it has been, it will, the level of M&A activity will really crush all prior years. We have a lot of clients that are PE-backed companies or companies that are looking for PE investment or PE investments or anticipating PE investments. And according to E&Y's mid-year report, PE firms announced $580 billion in new deals during the first 6 months of 2021. So seeing as though the previous high water mark was from 06-07, and that mark was at $750 billion in deals, again, if the trend continues after May and through the rest of the year, the M&A activity is really looking to hit unparalleled levels. We've even seen companies, and I'm not sure, all the people that are attendees now, some may be at PE-backed companies, some may be at long-time operating companies. We've even seen a lot of our clients who were not thinking about selling, who have operated their businesses for a couple decades. As a lot of the executives and long-term employees are getting older, they're getting approached with offers that they cannot refuse. So the M&A activity isn't just happening with new companies, new tech companies, companies like that, but we're seeing it happen with long-term operating companies, small private companies, mid-size, large companies. So, no company is really insulated from this. I think there's a good chance that, a lot of people on the call have already been through maybe a merger acquisition, or in the next several years will be considering one, or their companies will be considering one. So we wanted to go through this topic and talk about the due diligence process and talk about the fiduciary issues to consider. And you can go back one slide. So many of you are probably thinking, how does the M&A activity specifically impact retirement plans? Well, as you know, anytime a company is consolidating or looking to purchase another company, the company has to determine, with assistance from its counsel and advisors, if there are retirement plan liabilities that must be considered, how the plans compare to the company's existing plans, and ultimately what to do with the plans. Do we continue the plans? Do we terminate the plans? The diligence process is really about identifying compliance issues, managing risk, and then planning for integration. And given these important issues, once a deal is on the horizon and the formal diligence process starts, it's a good idea to get your trusted advisors involved, whether it be your internal HR lead or VP of HR. Really important for that person to be in on the process. Your 401k investment advisor, legal counsel, and any other trusted advisors that you have. Those individuals are used to dealing with confidential transactions and helping clients through that process, and particularly on the retirement plan slide. So I also want to mention that a lot of the slides are written from the buyer's point. The next couple slides are written from the buyer's point of view, but they're all relevant even if you're on the other side of the transaction, as well as you're an advisor assisting the parties. So because the goal is really in the diligence process is to identify compliance issues with administration or legal issues, I think it's a really good idea to have your fiduciary lens on when we think and we talk about this diligence process. So and you can think about it, if your company is being sold and and another company and their legal counsel are diligencing your company, where do you stand up in terms of proper compliance, administration, and legal qualification issues? Are there areas that you know of that you can shore up because you know that they're going to be asked in the diligence process? Is there documentation that you're missing that you should really be thinking about? Well, I think through that lens when we go through this next slide, and I think we'll learn a lot. Next slide. Oh, we can stay on this slide. So the first step in the diligence process is really to understand the form of the transaction, understand the deal. Is it an asset deal where the company is just purchasing substantially all the assets or specifically listed assets? Or is it a stock deal or merger where the company is going to buy all the stock in a subsidiary, or they're going to buy all the stock in this big conglomerate company with a bunch of different companies? That's the first step. In an asset deal, unless the buyer adopts or continues seller plans, buyer generally will not assume any liabilities. Seller retains these liabilities. But in stock deals, buyers generally assume not only seller's benefit plans, but also the plan liabilities. All historic liabilities and compliance issues and other legal concerns that impact those plans, buyer assumes those things. So as a result, the extent of the diligence is generally more thorough in stock deals. Next slide, please. So what are buyers' concerns in an asset deal? Well, because buyer will be purchasing a specific list of seller's assets, you want to make sure that the benefit plans are treated as excluded liabilities unless they are specifically being assumed. So I think if the HR lead and VP and the people that are involved in the deal are thinking about retirement plan, what needs to happen with the retirement plan, they need to make sure that the retirement plans and all other benefit plans that you don't want to assume are specifically listed as excluded liabilities. Now, this second bullet is really where your HR lead and advisors come in. You need to understand what benefits covered the acquired workforce pre-deal, what benefits you want to provide them after the deal closes, and whether it's possible to put employees on buyer's plans following closing. So if for some reason if you're acquiring a group or acquiring assets and a large number of employees are going to come along with that deal, if you have 100, 200, 300 employees, it may not be possible to transition them onto your plans immediately. And those conversations about what it takes to transition them onto your plans need to happen early, so that if for some reason you need to plan for transition services, either those employees stay with seller for a period of time until they can be migrated over to buyer, or they just come over to buyer and stay on seller's plans for a period of time. Those conversations, those things need to be thought through, and those conversations need to be had. So even though retirement plans will not generally be assumed in an asset deal, conducting diligence is still prudent in order to understand, as I mentioned, what level of retirement benefits were provided to the workforce as compared with the new company. Is there any successor liability that we need to be thinking about? In 401k defined contribution plans, there should never be any successor liability if you don't assume the plans. But in other types of plans, like cash balance plans or other defined benefit plans, maybe retiree health on the health side, there are successor liability issues to think through. Another thing to be thinking about is, even if you don't assume the plans, the buyer is going to have to decide, are we going to allow people to roll over their assets into our plan? Are we going to be able to roll over, are we going to allow them to roll over not only their assets, but also their loans? A decision regarding loans is really a sensitive one, because absent the ability to roll it over to the new company, those loans will be automatically defaulted. And so that's one thing that oftentimes won't get picked up maybe by legal diligence, and it's something that your HR leads or you all or your legal counsel can really sort of give a value add. And you can start talking about, what are we going to do with people that have outstanding loans? The last thing we want to do when we're bringing over a new group of employees over to our company is to say, hey, here we have all these new benefits and everything is all great, except, oh yeah, your 401k loan is going to be defaulted. So planning for those types of things is really important, and having advisors that know those issues and can identify them and tee them up is really important. Next slide, please. Now, as I mentioned at the onset, the treatment of plans in a stock deal is much different than an asset deal. In the case of a stock deal, the buyer steps in the seller's shoes and assumes seller's plans and benefit liabilities. As a result, any operational or legal compliance issues will be inherited. And oftentimes, the treatment of the plans may depend on the structure of the transactions and where the plans are maintained. So if you purchase a company that sponsors the plans, you'll inherit the plans and all of the legal compliance issues. If your company is acquiring a company that doesn't maintain its plans, it just participates in another plan, you'll assume some of the liability, the compliance issues and liabilities, but you won't automatically assume the plan in the deal. So in terms of diligence, the main goal at the onset is to evaluate obligations under the seller's plans as compared to your current plans and identify any compliance issues. As I mentioned before, this is a good time to get your advisors involved. So the diligence process typically involves requesting all plan documents, reviewing Form 5500s, requesting and reviewing discrimination testing. In the 5500s, you can look at, have there been delinquent contributions that haven't been corrected? If it's a multiple employer plan, or we have multiple participating employers, have they all signed participating employer agreements as generally required by prototype plans? Is the plan documentation in order? Take a look at the plan audit. Is there something in the plan audit that shows a recurring issue with delinquent contributions, or a forfeiture account that just has rolled over from year to year to year? You can really get a lot from just looking at those items. On discrimination testing, have they had discrimination testing problems in the past? And if so, have they been corrected? As you all know, I mean, discrimination testing sort of initial failures are not uncommon, right? They happen depending on the plan design and the plan makeup. So it's okay to see maybe there have been discrimination plan issues as long as they've been corrected. It's also a good time for your 401k investment advisor or other trusted advisor to take a look at the investments that are in that other plan, how they may be mapped over to the new plan. Is there employer stock in the plan, or some other type of investment that sort of would cause caution flags or even red flags to your company or to your advisors? That's really important in the diligence process. Diligence may uncover compliance issues that either have to be corrected before or after closing. For example, if there's been a qualification error or another operational error, it's happened several times for us in the last couple of years where we've required the seller to prepare and file a VCP either before or after the transaction is done. Our client is taking over these plans, and there's an operational issue. In a couple of those cases, it's been because they've done a lot of acquisitions and they haven't had the other participating employers execute participating employer agreements. And prior to the new EPCRS, the only way to correct that, if you don't have one of those agreements in place prior to when the new employees begin participating, is filing a VCP. So sometimes it does uncover compliance issues, and a lot of the issues with 401k plans are not red flags. They're not going to stop a deal. They're not going to prevent a deal from happening, but they're going to be yellow flags that need to be dealt with and need to be worked through, oftentimes prior to closing. If there are compliance issues that are identified, like a qualification error or a significant operational failure, we recommend that buyer get indemnified for all those significant compliance issues. So that's part of the deal process, and it's important that if you're taking on those plans, that you talk about getting indemnified for them if they ever come up in the future. Next slide, please. So in the case of a stock deal, and even an asset deal too, but particularly a stock deal, the most important decision is to determine whether target's plan will be terminated prior to close or continued past closing. Now, for defined benefit plans like cash balance plans, oftentimes the question is, does the buyer want to continue that high level of employer contributions or the specific compliance issues and complexities involved with defined benefit plans, cash balance plans? For 401k plans, the only opportunity you have to terminate that 401k plan is prior to close as a result of the successor plan rule. Now, the successor plan rule is a bit convoluted, but it generally says that if a company terminates its 401k and allows distributions, that it cannot sponsor another or a new 401k plan for 12 months and cover the same individuals. So if the only opportunity you have to terminate the 401k and allow those sellers' employees to get distributions is prior to the deal closing. If you wait until afterwards and you try to terminate, you can terminate it, but according to the successor plan rule, you wouldn't be able to let those employees onto your plan for 12 months. And because that would generally be sort of an HR nightmare, the decision has to be made prior to close. Are we going to require seller to terminate their plan prior to close, or are we going to let it continue after close and then merge it afterwards? Now, the one thing to think about if you keep the 401k plan in place and merge it afterwards is that because afterward that new company is going to be in your control group, according to discrimination testing rules, you're going to have to test all of those groups together. Now, helpfully for coverage testing, there's what we call the M&A transition rule, and I won't go into detail about it, but essentially allows a company to maintain a separate plan during an M&A transition period without running afoul of coverage testing. So that M&A transition period can be pretty long. It's generally the end of the plan year after the plan year in which the transaction happens. So it's possible to maintain that seller's plans for a period of almost up to 2 years, depending on when the transaction happens, and then later merge it. Now, this last point is to highlight that there are special issues for simple 401ks and IRAs. So some of your companies may maybe purchasing another company that's relatively small. They don't have a large, 401k plan with a prototype plan or a big prototype plan sponsor. They have a simple 401k. The one really important thing to remember on a simple 401k is that they have to be maintained for the entire plan year, and there's no M&A exception. So if you purchase a company with a simple 401k or an IRA, you have no choice but to continue that plan through the entire plan year. And on ESOPs, if the seller maintains an ESOP, it's best to flag this as soon as possible, as there is an entire different analysis and calculation that has to be done if an ESOP is involved. Next slide, please. In terms of the decision to terminate or merge the 401k, it's often based on compliance issues, but it's also often based on the ability to transition the buyer's plans. So I mentioned this issue before. If you are buying another company and there's a significant number of employees, you may not be able to transition them immediately over to your 401k plan. Sometimes that's driven by payroll issues. And David and I aren't payroll experts, but we work with a lot of HR professionals at companies that are. And oftentimes it's more challenging to migrate payroll than it is on 401k on the 401k side. So often the decision about can we have them terminate prior to close, or are we going to have to continue it after the fact, is based on how quickly payroll can be transitioned. Sometimes it's an issue with 401k record keepers and how quickly they can establish the new feeds that are necessary to transmit information. If you decide that you are going to terminate the 401k plan prior to close, what are the things that you need? What do you think the things that you need to do? And these also are settlor decisions, but they also sort of bleed into fiduciary issues in terms of administering the decisions that's made by the company. So if you're going to terminate the 401k plan prior to close, you want to make sure that in the purchase agreement, you require the termination in the purchase agreement. Oftentimes it's a condition to closing. or a covenant to closing. It'll say that one of the conditions to closing is that seller terminate its 401k plan and deliver resolutions indicating that it's done that and it's amended the plan. As I mentioned, oftentimes it requires the seller to approve the termination and go through whatever steps are necessary to amend it prior to or concurrent with closing. And also the buyer has to decide whether it'll accept rollovers, including rollovers of plan loans. And administering that process and deciding how rollovers are going to happen and how rollovers of plan loans are going to happen is really sort of bleeding into the fiduciary part of this. The plan administrators are going to have to determine how do we do that and how can we do it most effectively. You have to decide which party will be responsible for winding up the plan. So even if you require the seller to terminate the plan prior to close, guess what? You've purchased the seller, right? This is a stock deal. So that new HR department and the seller is now part of your company. So you don't just wipe your hands clean of it. You have to decide, are we going to have the same people at seller that were responsible for the plan prior to close still handle the wind up, or is our HR group, is the new company really going to be responsible for winding up the plan, working with the record keeper to process determinations, possibly seeking a retirement plan or a determination letter from the Iras. So those are all the things necessary if you're going to terminate the plan. If you're going to assume the 401k plan and later merge, there's a couple things you need to think about. Number one is you have to check the plan documents to see if amendments are needed to exclude related companies. So oftentimes, depending on the prototype plan sponsor, it may say that related companies automatically participate in the plan. Well, if you're going to keep these plans separate for a period of time, the last thing you want is a plan document that says the seller's employees are going to participate in their plan. And guess what? By operation of the prototype plan, they're also automatically eligible for the new plan. So if you don't intend that to be the case, you want to make sure that any amendments are done prior to closing to make sure that you've excluded that group. You also want to make sure that the M&A transition rule is satisfied. In order to do that, you can't make changes to eligibility or benefits during the transition period. So you want to keep that rule in mind when you are maintaining two separate plans after closing. And you also want to communicate with your current record keeper regarding the plan merger process. I know some of you have probably been involved in plan mergers, but we're doing a couple of them right now, and oftentimes the major record keepers are saying it's normally a 3-month process, that involves mapping and blackout periods and lots of communications to participants. So communicating with your record keepers, your 401k investment advisors early on when you know you're going to merge the plans after the fact is really important. Next slide. So now I'll turn it over to David to start talking about general regulatory updates. But if anyone has any questions about retirement plan due diligence and M&A, there may already be one or two. Happy to tackle those now, Brian, or do that after the program.
Thanks, Doug. It doesn't look like anybody has submitted a question right now, but we would remind you, if you do have a question for either David or Doug, please do submit that through the Q&A function. I'll keep up with those, and then when David's done, we'll try to address everybody's questions at that point. So David, I'll turn it over to you for the regulatory update.
We want to be respectful for everyone's time. And so what we thought we would do with this remaining time is just hit on some regulatory updates. Next slide, please. The first one is what we call Secure 2.0. It's the Securing a Strong Retirement Act of 2021. This is a kind of building on the Secure Act of 2019. Right now, it hasn't been passed, but it's expected to, the Senate and the House. So I think you can count on these being new areas of law. The likelihood is very high that this will pass. Some of the key provisions, mandatory auto enrollment and auto escalation is going to be required for new 401k plans and 403b plans. which that means generally existing plans, plans that exist before enactment will be grandfathered. They will not be subject to that rule. Under the Secure Act in 2019, 401k plan sponsors are required to allow long-term part-time employees to participate in the elective deferral portion of their 401k plan. That was defined as an employee who works 3 consecutive 12 months periods with at least 500 hours of service. Secure Act 2.0 accelerates that. Instead of 3 consecutive 12 months period, it reduces it to 2 consecutive 12-month period. The required minimum distribution age when a participant must begin distributions from the plan under the Secure Act of 2019, it was increased very subtly from 70 and a half to 72. Well, you see under Secure 2.0, they're going to push out the required minimum distribution date even further. 73 in 2022, 74 in 2029, and 75 in 2032. So that's pretty substantial change. Higher catch-up limits will be in effect. Right now, you know, when you're in a 401k plan and if you're 59 years old, you can make greater elective deferrals that are called catch-up contributions. Those are going to be increased. I think it's 6,500 now. You'll see much larger amounts for participants once they attain age 62, then 63 and 64. So it will keep increasing. I think everybody has seen a lot of media on student debt, and there was actually a private letter ruling recently where a company was allowed to match contributions to a 401k plan based upon student loan payments. So that's going to be included as part of the bill. It will be something that will be encouraged actually nationwide. And then just one quick one, de minimis financial incentives will be allowed kind of for participating in the 401k plan. Very similar to what we do for health and wellness program. And it would be, you know, something small that if you elect to be in our plan, there's some form of reward that you receive. I don't know if it would be a free lunch or free dinners, but it would have to be of small value. But it's going to be, we will be able to give participation awards to our employees. So there's also another provision on lifetime income disclosure. Next slide. And Doug's going to work through this one real quick for you.
Yeah, so this is just wanted to quickly touch on this given time. You know, the agencies in charge of retirement security, both the Iras and the DOL, have over a number of years been increasingly concerned that participants don't understand how long their retirement plan assets will last, that they will not have enough assets to last later in life. A number of years ago, the IRS made efforts. They adopted and allowed QLACs, qualified longevity annuity contracts, which would have allowed, or which do allow people to start an annuity later than RMD age to ensure that they have, you know, sufficient retirement assets for retirement. This is the DOL's attempt to make sure that people are aware of it as well. This was part of the Secure Act. The Secure Act requires plan administrators to provide participants with a lifetime income illustration, at least annually. And this illustration must include 2 illustrations of a participant's account balance converted to a lifetime income equivalent. One is a single life annuity and another is a qualified joint and survivor annuity. So the IRS issued rules in August of last year that left a lot of questions open, but just in July last month, the DOL issued guidance, but just last month, the DOL issued a brief set of FAQs clarifying a number of issues. Probably the most important one is the effective date. Although the effective date of the disclosure requirement is on September 18th of this year, plans are only required to provide it once annually, and most participant-directed plans can provide the first disclosure as late as the second quarterly statement sent to participants in 2022. And the DOL also indicated that it's going to issue a final rule soon. So our recommendation is to talk about it with your record keepers, but sort of hold steady and wait for the DOL to issue its final rule. And then my guess is record keepers and TPAs will start to get those disclosures ready, and you can work with them in the first quarter of 2022 to get that done. Turn it over to David for the next slide.
Next slide, please. There are recent changes to what we call the Employee Plan Compliance Resolution System, EPCRS. And what this system does is a process for plans sponsors to correct either document problems, compliance problems. It's an ability to go in and correct errors in your plan. And they've loosened it up. Is what they've done is made it a little bit more receptive for plan sponsors in a couple of areas. One thing, the ability to self-correct means you do not have to report yourself. You do not have to file a user fee. So we try to self-correct and fit within the parameters of self-correction as much as possible. The old law was that if it was viewed as an insignificant operational failure, just to say that's an error, you could correct it anytime. Well, that continues. But now, even if it's a significant operational failure, you're allowed 3 years within which to self-correct, that's a pretty generous time frame. So that's very well received. They have eliminated anonymous filings where we could actually, go to the Internal Revenue Service and not even identify ourselves and test the water, so to speak. Here's the error that occurred. Here's how we want to correct. And if we didn't get the right answer, we just never identified ourselves. But that's gone away. Now you're going to have some kind of you're still going to be able to talk to the Internal Revenue Service on an anonymous basis, but you won't be able to get basically an anonymous submission anymore. Overpayments is a subject that happens often. It's when a participant's paid too much, and sometimes it's very negligible. They've softened the rule on when plan sponsors have to go after overpayment. They've given plan sponsors much more freedom that really they don't have to. And certainly if they're de minimis, which it now is defined as $250. So it's they've expanded EPCRS, and I think very favorably for employers. Next slide, please.
Yep, and I'll just quickly mention this slide. If anyone has in the past or intends to select discretionary 401k matching contributions, the IRS is requesting or requiring prototype plan sponsors to have plan sponsors really identify the method in which they're going to make those contributions, how they're going to allocate them. So there's more sort of tight constraints around that. Previously, you could just check the box for making discretionary matching contributions and didn't have to select the computation period and how it would be allocated to participants. So now you'll start to see this year and next year prototype plans requiring more specificity. There's also new notice requirements by employers. And given the interest of time, we're going to skip through this slide and also the next two slides regarding litigation. I do want to point out on the last slide regarding litigation, there are some really interesting cases about standing, particularly the last case on the next slide that I want you all to take a look at. It's particularly relevant for defined contribution plans and whether ERISA plan participants have standing to sue the plans and fiduciaries if they can prove no harm or no impact by the decision. So we'll let you take a look at those slides after, but wanted to leave just a minute or two or a couple minutes for questions.
Dave and Doug, thanks for taking the time today. It doesn't look like at the moment that we have any questions. I would remind everyone, we have recorded this session. If you give us the afternoon just to clean it up a bit, we'll post it on our YouTube site. You can go and review that or pass it on to someone else to review. You can do that by going to youtube.com/watchpnfp or just search Watch PNFP through your YouTube app or contact your financial advisor and we'll be happy to provide a copy of today's webinar to you. David and Doug, I'm watching for questions. It doesn't look like we have any. I'm assuming that means you all did an excellent job of covering the material. Thanks so much for spending some
Appreciate
time
you, Brian.
with us. Yeah, absolutely.
Thank you.
We appreciate your partnership. Thanks to the Trust and Investment Services area of Pinnacle Financial Partners for sponsoring this webinar today. We hope that you found it helpful and look forward to being with you again next time. Hope you all have a great day.